and Jackson versus State 25 Southern 3rd 518, which is also from the Florida Supreme Court from 2009. So the question now before the court, I believe, this being a motion for mistrial, is does the statement that was elicited from Ms. Bedwell, that Ms. Bedwell testified to yesterday in court, does it vitiate the entire fairness of this trial? And the statement that she testified to was, and I don't remember her exact words, but very similar to the statement, of course, that was subject to the motion in limine, that the defendant threatened to shoot my baby and urinate in his face. The state's position, Judge, is that in light of the overall allegations in this case, that this does not vitiate the entire fairness of the trial. And the state has also provided Torres versus State, which is 834 Southern 2nd 342, which is a 3rd District Court of Appeals case, and which basically holds that prior threats of the defendant toward the victim are relevant and admissible at trial and are not subject to a similar fact analysis. And that's basically what was elicited, or what Ms. Bedwell testified to, was a prior threat by the defendant toward the victim. And the state's position is that in light of the basic allegation of first-degree murder here, is that the defendant took a living baby and threw this baby out the window of a car as it drove down I-275 South. And I know, of course, the state and the defense disagree on whether that's what the evidence shows, but I anticipate that the evidence will show that, and the state will be able to argue to this jury that that's a reasonable inference that they can infer from the evidence. So in light of that, Judge, the state's position is that the statement that Ms. Bedwell testified to yesterday, although in violation of the court's motion or order in limine, does not vitiate the entire trial, and that the motion for mistrial should be denied.
Just briefly before Mr. Gale steps away, too, Mr. Gale, I believe from our conversations you agree to acknowledge the fact that you never specifically instructed Jasmine Bedwell of the order that had been entered by Judge Fuente in this case with regards to this.
That's true. I did not instruct her during our preparation that you are not to say this specifically, but it never came up, and I don't believe I had any reason to believe, based on everything that I had seen and heard and read and discussed with her, that that would be her response.
And I only asked it for the purpose of clarifying that factually for the record. Your Honor, I understand that Mr. Gale was acting in good faith manner when in this case. What's different about this case than Mr. Gale's argument recognizes is that the statement that was made by Ms. Bedwell yesterday comes really from a prior case. That's the case of State of Florida versus Richard Anthony McTear Jr. in case number 09CF005749. And that case was tried to a jury with a jury verdict being returned on or about February 3rd, 2010. And that verdict was a verdict of not guilty in that case where the actual allegations were made. And that's a significant factor for the court to consider in determining in this particular case whether or not a mistrial is warranted. I also want to provide some case law to the state, or to the court. I've provided it previously to the state. Henderson versus State, found at 789 Southern 2nd, 1016, a 2001 2nd District Court of Appeals decision. The case of Gerald's, Geralds versus State, case found at 601 Southern 2nd, 1157. That's a decision of the Florida Supreme Court from April 30th, 1992. The case of Cooper versus State, 659 Southern 2nd, 442, a decision of the 2nd District Court of Appeals case that was decided on August 16th, 1995. It's an appeal actually from this circuit court to the 2nd DCA. The case of Howard versus State, found at 950, that's 950, Southern 2nd, 1260, that was decided March 16th, 2007. and the case of Burr versus State, a Florida Supreme Court decision found at 576 Southern 2nd 278 from January 18, 1991, and a decision of the 4th District Court of Appeal, Moore versus State, which is not yet in the official reporters and has a Westlaw site of 2012 WL 6601390. If I may approach, I'll provide copies of these to the court. Briefly, with regards to each of these cases that I have now provided to the court and have provided copies of to Mr. Gale, the state attorney, the position that the state has that a mistrial should be granted only if the statement vitiates the entire trial, we're of a position that in this particular instance that it does vitiate the entire fairness of the trial. Starting with the case of Henderson versus State, found at 789 Southern 2nd 1016 from 2000. The case provides that a motion for mistrial should be granted when it's necessary to ensure that the defendant receives a fair trial. When a curative instruction would be insufficient, the trial court should grant a mistrial. And that's the general statement of law that exists with regards to the issue that's currently before the court. In the case of Geralds versus State, 601 Southern 2nd, this is an appeal from a conviction of capital murder, and the primary issues in the case go to some evidentiary issues. But as a general statement of law found within this case, although the case is not directly on point for its primary issues, case states, although the judge gave a so-called curative instruction for a jury to disregard a question that existed in the case, such instructions are of dubious value. Once the prosecutor rings the bell and informs the jury that the defendant is a career felon, the bell cannot, for all practical purposes, be unrung by instructions from the court. And here, in the cause that's currently before the court, the statement that was made isn't something like a prior conviction. It isn't something like it's a secondary matter to the issue that's being tried before the jury. In this particular instance, it's a direct threat to the baby of an intent to kill the baby, and obviously the matter before the court for the jury's decision is an issue of whether or not Mr. McTear is guilty of killing the infant in this cause. In case of Cooper versus State, found at 659 Southern 2nd 442, the defendant was on trial for an attempted first-degree murder, and in that case, the victim testified that the defendant's daughter had told her that he had raped her. The defendant moved for mistrial, and the court instead gave a curative instruction in that case, and it was found that the evidence in the case boils down to the jury having to accept the victim's or appellate's versions of facts, and the court found that the statement was so prejudicial that a curative instruction under those circumstances was inadequate. In the case of Howard versus State at 950 Southern 2nd 1260, in that particular case, the state did not oppose the defendant's motion in limine that had been filed, similar to the facts that are before this court, where a motion in limine had been filed by the defense, specifically directed to the statement that was ultimately given or made by Jasmine Bedwell. And similar to the case that's before the court, they had agreed or not opposed the motion in limine, and concerning the victim's statement that the defendant had raped her in the past. The witness intentionally violated the order. In that particular case was the finding, and it did not appear from the general question that the state asked that the state attorney intended for the witness to violate the motion in limine. And I acknowledge that for the purposes here, that Mr. Gale asked a question that he asked, as is indicated in the record, and he has acknowledged that he had not specifically instructed the victim not to testify to those matters, although they were matters that have nothing to do with the matter that's directly before the court. Last but not least, in the case of, actually it's two cases, Burr versus State, 576 Southern 2nd 278, which was, and the reasoning from that case was more recently adopted in the case of Moore versus State at 2012 Westlaw 6601390. Although in that particular case, the evidence that was at issue, or the testimony that was at issue, was ultimately found to be admissible for first phase purposes. It was found not to be admissible for second phase purposes, and these cases are cited to the court for the recognition of the fact that a double jeopardy issue, a basic constitutional double jeopardy issue, exists where a defendant is placed into a position of having to essentially defend against statements that were used in a prior prosecution in which the defendant was found not guilty, which is the facts that we have before the court at this time. The Smith and Jackson case that's filed by the state state that, as he was argued, that in order for a mistrial to be granted, the testimony has to vitiate the entire trial, and it would be our position that in this instance it does. The Torres case, although arguing that prior threats are both relevant and admissible, we don't argue about that general proposition of law, but the reality is two things in this case. There is a prior finding of not guilty with regards to the allegations, and second, and of additional significance, is that notices of Williams Rule evidence or similar fact evidence had been filed by the state. Whether they intended or did not intend to use that testimony in the course of the trial, there are an original order and actually a modified order after the jury's finding of not guilty with regards to that potential Williams Rule evidence.
Are you talking about in the prior trial?
In this case itself.
Are you saying now that the state had filed a notice of intent to use Williams Rule evidence in this case?
Yes. And the court has also ruled with regards to that Williams Rule evidence that anything that relates to the trial in which the defendant was found not guilty would not be admissible for Williams Rule purposes. And it's the testimony from the trial in which the defendant was found not guilty that the statement made by Jasmine Bedwell comes from. So that's the additional reason why, in the situation that we find ourselves in, and the orders having previously been entered the court, quite frankly, there doesn't seem to be an option other than the granting of a mistrial in this cause. Thank you, Your Honor.
Thank you. Anything else from the state?
Excuse me. No, Your Honor.
If you all will bear with me for a little bit, I'm going to go to my office and make a decision and come back. I think our jury should be back at 9:30.
Yes.
I'll be back before then.